Let's begin our presentation with getting to know what does judicial interpretation means. Judicial interpretation is an interpretation made based on textual interpretation where the court, inter alia, federal court interpreted the law which is in the form of text. The reason why the judge has the duty to interpret the law is to seek the intention of the law, which could mean meaning, purpose, objective, reason, other than reading the literal meaning of the provisions. Thus, the necessity of the interpretation of law would only apply when the law is written in ambiguous words, unclear, and could hold two different views, or the provisions could hold different meaning. It is clearly beyond doubt that the one who is vested with the power to interpret the law is the judiciary body, which is among the three organs of the government. Although it is the organ that is given the power to determine the law, but it is still under obligation to obey the written constitution, which is the supreme law of the land, inter alia, federal constitution. The court would interpret the law based on certain methods or modes to seek the meaning or purpose of the law itself. There are a few common methods used by the court, which are textualism, original meaning, judicial precedent, pragmatism, moral reasoning, national identity, structuralism, and historical practices. One of the parts in law that needs further elaboration by the court is Part 2 of Federal Constitution, which consists of fundamental liberties for each individual in the Constitution. The mere declaration of the fundamental liberties would not be effective and meaningless if the judiciary did not have independent capability to interpret and ensure the enforcement of it. This is because some of the words provided under these parts covers a very wide scope of circumstances. Thus, it needs to be determined by the court in a specific way. Therefore, we are going to look at three examples of fundamental liberties which were interpreted by the court. First, liberty of a person. Second, equality. And third, freedom of speech.
Firstly, Article 5 Clause 1 read, "No person shall be deprived of his life or personal liberty save in accordance with law." The second clause is right to habeas corpus. The third clause is right of an arrested person to know the reasons on the ground of his detention and hire legal practitioner to defend himself. And Article 5 Clause 4 stipulate right of an arrested person to be produced before the magistrate within 24 hours. The wording of person in Article 5 Clause 1 is applied to all the citizens and non-citizens. However, the question is, to what extent the word life and personal liberty should be covered, as is not clearly defined in the Constitution. Therefore, it depends on how the court interprets the provision, because the ambit of right to life and right to personal liberty under Article 5 Clause 1 is uncertain. In some circumstances, right under Article 5 Clause 1 can be taken away by any law enacted by Parliament, as the word save in accordance with law makes the constitutional right under Article 5 as not an absolute right. This can be seen in the case Tan Teck Seng against Suruhanjaya Perkhidmatan Pendidikan and another, whereby this case was concerned with procedural fairness and constitutional rights of a civil servant facing dismissal. In this case, the appellant, a senior assistant in primary school, was charged on the ground of breach of trust, and in consequence of that, he was dismissed from the service. The judge in this case posited that life under Article 5 is not referred to mere existence, but expression of life must be read with a liberal and not literal approach in order to develop the true intentions of the framers of the Constitution. It must be incorporated with all those facets that are integral part of life itself and all matter to achieve quality of life. Therefore, the court is interpreting the word life in Article 5 to include the right to livelihood, and as the appointment is part of fundamental right, reading this expression, the appellant has been viewed in deprivations of gainful employment without a fair hearing. Meanwhile, in the judgment in the case Pihak Berkuasa Negeri Sabah against Sugumar Balakrishnan and another, Federal Court disagreed the view of Court of Appeal on the interpretations of word. Personal liberty should be broadly including all those facets that are integral part of life itself and those matters which go to form the quality of life, as the entry permits only confer right for the appellant to enter and reside in Sabah, but not confer any right of livelihood in the state, as he was not a person born in Sabah. Therefore, Federal Court overruled the interpretation made in the case Tan Teck Seng, and the respondent's rights to practice his profession in Sabah could not be seen has infringed his right under Article 5. Next, in the case Sivarasa Rasya against Badan Peguam Malaysia and another, the right to personal liberty includes the right to privacy, whereby the judge also adopted liberal approach in interpreting Article 5, Clause 1 of Federal Constitution. According to the judge, the fundamental liberties must be generously interpreted. Therefore, this can be seen that the modes of interpretation used in this case is same as in the case of Tan Teck Seng. Moving on to the case of government against Loh Hwai Kong. This case mainly about the freedom of movement as the appellant who permanently lived in Australia came back to Malaysia but he was charged with criminal offence. He surrendered his passport as the condition to get bail. Then he filed a suit asking the government to give him a new passport on the ground his right to travel to abroad is the fundamental right under Article 5. But the judge in this case interpreting the word personal liberty as does not include the right to travel overseas nor the right to own a passport. It only merely concerns the body of the individual, whereby the freedom from unlawful detentions or arrests. Article 5 Clause 2 give right to detainee to writ of habeas corpus. Generally, a writ of habeas corpus is used to bring the detainee before the court to determine if the person's imprisonment or detention is lawful. This is a part of fundamental right highlighted in the Constitution to protect the person from unlawful and indefinite imprisonment. In Abdul Ghani Harun against Ketua Polis Negara and another, the judge viewed the right for the court to apply a writ of habeas corpus was not a merely legal right but also a constitutional right available to any person who believes that he has been unlawfully detained. In addition, the judge takes a literal approach that the detaining authority has no duty to produce the detainee in court unless the court is certified that detention is tainted with illegality. However, there's a few situations and circumstances which the habeas corpus will be inapplicable as there is always restriction for every right stated in the Constitution. It can be seen in the case Sejaratul Justinar, whereby the appellant was arrested under the ISA, International Security Act, and the appellant's mother filed an application for the issue of writ of habeas corpus in releasing the appellant. Before the learned judge of High Court delivered her decision, the appellant had been placed under a restriction order and thereby the judge dismissed the application for habeas corpus as the appellant was no longer in detention. In the judgment, the judge stated that a writ of habeas corpus is only available to a person who is being physically detained unlawfully. Therefore, in this case, it can be clearly seen that the appellant was a restrictee and not a detainee, whereby the appellant could not raise a writ of habeas corpus. The writ of habeas corpus is also inapplicable if the person understands and acknowledges the statement of in-inquiry proceeding, whereby this can be seen in the case Murali Bakovijigam. Article 5 Clause 3 highlight three main rights, whereby the first one is right for the arrested person to be informed on the ground of his arrested, and then the second one is right to consult counsel, and the third one is right to be defended by a legal practitioner of his own choice. While in Article 5 Clause 4, it laid down the right of an arrested person to be produced before the magistrate within 24 hours and prohibit further detention without court authority. Clause 3 and Clause 4 do not apply to an enemy alien. In the case O. Apua, the court held that a balance has to be centralized between the right to arrested person to consult his lawyer and the duty of the police to protect the public from the wrongdoer by apprehending them and collecting evidence as is against them. In this case, a delay of 10 days is reasonable as the crime because robbery has caused loss of money and life. If the accused was given an immediate exercise of right to counsel, it will interrupt this investigation. Hence, his application was rejected because his detention was lawful. It must be noted that the accused also entitled to be represented by the counsel of his judge only if the counsel is willing and capable to represent him, as can see in the case Muhammad bin Abdullah against public prosecutor. Therefore, in the case relating to Article 5, the judge will make the interpretation in viewing the objective and not only the subjective of the provision. They need to be creative as some wording in Article 5 is not clear and it depends how the judge uses the approach method in getting the best outcomes.
In general, Article 8 explains about the protections of any person from discrimination and inequality in any form of treatment received for all citizens that is under the law in Malaysia. Article 8, Clause 1 explains on the assurance that there will be equal protections of the law for everyone, while Article 8, Clause 2 explains on the prohibition from discriminating a person based on their background, such as race, religion, and gender. However, there are limitations under Article 8 in which the provision will not cover on any matter that is considered to be a lawful discrimination. Lawful discrimination means any law that exists in any statute. For example, Article 8 mentioned that the provision will not be applicable to religious matter. This can be seen in the case of Majlis Agama Islam Wilayah Persekutuan and Victoria Jaya Sil Martin and another appeal. Other lawful discrimination can be in the form of personal matter where Article 8 will not cover, as illustrated in the case of Leticia Bosman and Public Prosecutor and other appeals. In the case related to religious matter, that is Majlis Agama Islam Wilayah Persekutuan's case, the appellant is a non-Muslim who graduated as a diploma student in Sharia law and practice. She had applied to be a Sharia lawyer but was rejected by the respondent. She argues that the act of the respondent is considered to be an infringement on Article 8, Clause 2, about equality where the law prohibits any form of discrimination regardless of their background. However, it was held that there was no infringement of Article 8, Clause 2, where the actions of the respondent was considered to be a lawful discrimination, as stated in Article 8, Clause 5, Para B of the Federal Constitution. That Article 8 will not be applicable in any matter mentioned in Article 8, Clause 5. It was stated in the statutes itself, thus it is considered to be a lawful discrimination. Next, in the case of Leticia Bosman and Public Prosecutor and other appeals, where the 4 appellants were convicted for drug trafficking and 1 appellant was charged for murder. 4 of the appellant claims that Section 39B of the Dangerous Drug Act was an infringement under Article 8. It was held that there is no infringement of Article 8 as the sentence was charged against them was considered to be a lawful discrimination, where it was reasonable for the punishment to be imposed upon them. The court also highlighted that Article 8 is not absolute, in which it means that all action will not be protected under Article 8. For the suggestion, the author for the book of Washing the Tiger had made a research on judicial interpretation on some articles and discussed them in his book. Under Article 8, the first suggestion was to broaden the list of grounds of discrimination found in Article 8 that includes age, disability, health status, and nationality, in which these 4 points can be seen to have gained a number of inequality treatment. The second suggestion is ensuring that any provisions permitting positive action by making amendment on existing provision that previously has disadvantage and serves as the purpose of strengthening the usage of equality by creating a strict criteria that could be used internationally regardless of time limits and proportionality. The last suggestion is removing the list of exceptions to the prohibition on discrimination as long as it is reasonable and fulfill the criteria which was strictly regulated to ensure the objective is still achieved, that is, to impose equality to all.
According to Article 10, Clause 1 of Federal Constitution, freedom of speech is recognized as a form of freedom for individuals or groups in expressing their opinions. Firstly, every citizen has the right to free speech and expression. Secondly, all citizens have the right to assemble peacefully and unarmed. And thirdly, all citizens have the right to form association. Based on Dr. Muhammad Safar Hasim in Jurnal Komunikasi, the freedom of rights in the Constitution is defined as a symbol of courage in voicing out ideas, and it is parallel with democratic living. However, in Malaysia, the freedom of speech issue has provoked ideologies and values collision among Malaysian citizens. Consequently, it causes people to start arguing on the individual's authority and credibility pertaining their ideas, opinions, and perspectives. It is intended solely to give people an opportunity to carry out the responsibility as Malaysians. However, many has faced sanctions after the existence of the act that requires people do not exceed the limitation of talking and express their opinions. So there are factors that has been set out in Article 10 Clause 4 in imposing restrictions in the interest of the security of the Federation or any part thereof or public order under Clause 2A. Parliament may pass law prohibiting the questioning of any matter, right, status, position, privilege, sovereignty or prerogative established or protected by the provisions of Part 3, Article 152, 153 or 181, otherwise than in relation to the implementation thereof as may be specified in such law. In Article 10 Clause 1, it has assured the people to free speech and expression. However, in Article 149, it clearly limiting the freedom of speech. For example, in Internal Security Act ISA 1960, the Act aims to combat threats that would disrupt the planned safety and the security in the country. Anyone who is engaged in the activities that are categorized as the activities of this threat, you can take preventive detention for 2 years without trial. Even prisoners can be continued if the authorities believe the individual is still considered as a source of threat to any country. Next, in Sedition Act 1948, based on history, this act has been introduced to fight the communist terrorists who carried out the uprising in 1948. The act provides a number of offences in more aspects of incitement. Under Section 3 Clause 1A to Section 3 Clause 1F explains the element of incitement is viewed through the word, deeds, or any publications. Even seditious can also be specified in a variety of conditions. It can be proven in few cases. Firstly, in Nik Nur Hafizi bin Nik Ibrahim and others against public prosecutor. The High Court was of the view that Section 27 Clause 5 of the Police Act read together with Section 27 Clause 2 of the Act did not contravene the Constitution and that Section 27 of the Act was valid and constitutional. The appellants obtained leave to proceed with the present appeal. It was held that Section 27 Clause 2 and 5 were in law reasonable restrictions that were regulatory in nature and not prohibitory. The police force is duty-bound to maintain the security and public order in the country for the public interest. As such, Section 27 of the Act did not prohibit the right to peaceful assembly, was neither unconstitutional nor in conflict or inconsistent with Article 10 Clause 1B of the Constitution. Next, it also can be seen in the case of Mat Shuhaimi bin Shafi against public prosecutor, where in this case, the appellant was charged under Section 4 Clause 1 of the Sedition Act 1948 for the offence of publishing in a blog an article containing his views in relation to the laws of the Constitution of Selangor 1959. It was held that it is void and invalid by virtue of Articles 4 and 162 of the Constitution, as the Act did not comply with Article 10 Clause 2A of the Constitution and could not be objectively be said to be a reasonable restriction, nor did not fulfill the objective of Article 10 Clause 2A of the Constitution, and it was wholly disproportionate to the valid reason permitted by law to restrict the fundamental right of the appellant under the Constitution. And that is all. Thank you. Assalamualaikum warahmatullahi wabarakatuh and good day to everyone. My name is Khairunisa binti Muhammad Noor and my metric number is 054917. I will conclude our group presentation for today. Firstly, an individual liberty cannot be restricted even for a merely bureaucratic or constitutional purpose. The rule of law is there to protect, not to restrict, as we live in a free society. The restriction can never be justified, unless only insofar as this is necessary for the protection of those who need it. As the doctrine of liberty is solely individualistic, this simply means that no person should be able to do his own thing by sacrificing other people or the society overall. People's liberties can only be adversely affected by the proper amount of limitations, while the government is fully responsible and liable for their conducts. The rules are meant to exist to uphold society. However, when the law touches people's rights for the sake of public interest, the limitation of certain freedoms is appropriate but can never be made absolute. Judges must interpret the Constitution by giving life and meaning to the terms of the Federal Constitution. In order to bring to the standard of justice, the judges must carry new responsibility appropriately in the administration of justice. In other words, judicial activism or judicial legislation is necessary to the accomplishment of the objective of interpretation. This can become more crucial in particular with respect to the laws pertaining to the rights of the citizen or to the fundamental rights upheld in the Federal Constitution. In enforcing the rule of the law on fundamental freedoms, judges shall also ensure that justice is accomplished by following the prismatic approach of interpretation of the provision. Too much flexibility could lead to unpredictable cases such as racial riot in May 13, 1969. Living in such a multiracial culture, any word must be carefully taken into account since it may insult or offend other people's feelings. Although we have limitation for certain freedom, but it still ensures that the human right that each of us should have received. Thus, it never deprives anybody in the Constitution from the freedom they shall be getting as a human. Everyone has full freedom to do whatever they wish without breaching the rules set down in the Federal Constitution, which is made in order to protect one another. So that's all from us. I sincerely appreciate your attention today and I hope you guys will benefit from our presentation. Thank you and have a nice day.